Is there any reason why that 1511 is not repeated for this one?
My Lord, I cannot say that there was a reason in the minds of the Rules of Court Committee, but as I indicated a few moments ago, I wanted to finish my submissions on the supplement to the statement of case and then address you on the amendment, if respectfully, if that is a satisfactory approach. I wanted, because my Lord, my lady's question is getting back to the amendment issue, and I respectfully requested that I be allowed to complete my submission on the supplement to the statement of case, because I have a couple of authorities that I wanted to advance. So I will wait. I will wait. Very well. So in respect of the supplement to the statement of case, I have just referred your lordships to Amidu and Alawiye, and I proceed further to...
Professor,
yes.
I want to understand your argument. Your submission is that it has been the practice to allow supplements, and therefore this court should allow the supplement as a matter of practice. And you also refer, that's it, right? As a matter of practice. Not because the rules are, not because you can see an indication in the rules, but because going through the decided cases, you see that it has been the practice. Is that your submission?
That is not my submission.
What is your submission?
My submission is that your lordships, in their wisdom in interpreting and applying the rules in CI 16, have considered it an appropriate exercise of jurisdiction to allow, to grant leave for the filing of a statement of case. Your lordships have done that. And therefore there are precedents that show your lordships interpreting and applying the rules concerning view as well as the rules concerning appeal in a manner that allows for a supplement to be available to the court as part of the process of determining an appeal in one case and a review in the other case. That is my submission. And my lords, respectfully, I do not believe that the practice of the courts in terms of the precedent that I cited, I don't believe that that practice has simply been an arbitrary practice, especially when, as I show, there is a certain pattern and there is a certain consistency with which this court has enabled counsel to file a supplement where it considers it appropriate. And my lords, the next case that I want to cite, in fact, illustrates exactly this point as regards the court's considerations when an application is filed for leave to file a supplement of case. This is the case of Nora Otu and Reuben Otu, which is a civil appeal number J7/3/2015, and in that instance, a single justice refused an application to file a supplement to the statement of case. And then, when it went before the full panel, they upheld the decision of the single justice. And the reason they upheld that decision was not because the rules did not allow for a statement of case, but because the Lordship held, per Justice Badegbe, that this particular application was seeking to bring in new matter that was completely unrelated to the issues in the appeal. So in that case of Nora 02 and 02, the determination by the court was that in order to try to bring in new matter, the court would not exercise its jurisdiction to allow for leave. The court did not say that the rules do not allow leave. The court said, in respect of the new matter, we cannot grant leave. And my lord, the final case in respect of a supplement, the final case that I wish to refer to is again your lordship's, I'm sorry, there is actually one more case before I get to the final case. That is Nunu against Ataglo. Nunu against Ataglo.
Could you kindly spell Ataglo?
I'm sorry.
Kindly spell Ataglo.
Ataglo, A-T-A-G-L-O.
Thank you.
And that is civil appeal number J4/73/2018. That is a decision that your lordships rendered on the 28th of July 2020. And in that decision, Her Ladyship Justice Doji in reading the judgment of the court, as I think it was a unanimous judgment, Her Ladyship again refers to a supplementary statement of case filed by the defendant upon the orders of the court that the parties address us on the legal effect of a provisional land certificate. So in that case, significantly, the court itself ordered a supplementary statement to be filed in order to address a particular legal matter. And that was exactly what happened also in the last case that I would like to cite, which is a case consolidated rates decided on the 25th of June 2020, National Democratic Congress against Attorney General and Electoral Commission of Ghana and Mark Techi Bunsen. That suit, well, the first suit is numbered J1/9/2020. And the second suit, which was consolidated with it, is J1/12/2020. So National Democratic Congress versus Attorney General and the Electoral Commission of Ghana and Mark Techi Bunsen against the Electoral Commission of Ghana and Attorney General. Now, my lords, in that case also, in the decision that was read by Justice Professor Kuti, reference is made to the fact that the court direct case. So my lords, what I'm respectfully submitting is that your lordships have recognized that the supplementary statement of case, or the supplement to the statement of case, as we have referred to it, where it can assist the court to address the matters that are an issue before it, may be entertained. Where the supplementary statement of case can assist the court in addressing the matters before it may be entertained. Now, my lords, I would like to refer also to a decision which I do not yet have a certified copy of, but a decision made on Tuesday by your lordships in the case Republic versus the High Court, ex parte Attorney General.
My lords, I really do not think that we are here to argue the whole case, and I do not see it.
Citing that case in course of argument, yes, he's entitled to refer to a decided case. Even at the Supreme Court, you can refer to a Court of Appeal decision. Yes.
Very well.
Yes. It's just...
But I want to correct a wrong impression. The application was not merely to file a supplementary statement of case. The application was to file an additional ground of appeal. And it was ground of review, additional ground of review. And it was on the basis of the additional ground of review that the supplementary statement, you wanted to file a supplementary statement. So if you cannot file additional ground of review, then there is no need to file a supplementary statement of case. If the supplementary statement of case is based on the original grounds of review, it's a separate matter. There should be a distinction between just asking to file a supplementary statement of case in respect of the grounds of review that we have already filed, and then leave to file additional ground of review and then a supplementary statement of case because of that additional ground. There are two different things.
My lords, with the greatest respect, that application, which also happened to be filed by us, that application was indeed to add grounds of review and to file a supplement, and that supplement was to address not only the additional ground of review, but that supplement was even to address a ruling of the court in respect of bias, which we had applied for and we were still waiting to receive. That supplement was to address even that. And we were not allowed on the simple basis that the rules regarding review
did not provide or did not allow for such.
Mr. Chikata, if I recall, that supplement was also to allow you to fill in holes that you had left in your submissions. So if we can get back to today's business, please.
We did not, it was not meant to fill in holes, and that may be your Lordship's interpretation.
The holes were numbered Q and N0. I was in O. I was actually part of that panel. Thank you.
The whole, your ladyship, the grounds were numbered Q, R, S, T. I'm not sure I know what the Q, N, and O that you're referring to. The grounds were numbered Q, R, S, T were the additional grounds that we sought. My lords, I mean, the documents are there, so there's perhaps no need to try to dispute, but I don't know what the O that you're referring to is.
Omissions, you said, if you remember, you said you had applied for the order of the court and you have not received the order. And so you left some holes, some missing holes.
No, my lord,
you had applied for an order from this court and you have not received the order.
My lords, with the greatest respect, what we said was that in the draft statement of case, which we attached to our affidavit, where we had Q and R, yes, there was nothing written under Q and R. It was blank. It was blank, and we gave a reason. The reason is that we have not received the ruling to enable us to address the funds. Well, I mean, the rather colorful language of filling holes may not apply to what we were seeking to do, because
Mr. Tikat, I think we should have timed you.
I'm sorry.
I think we should have timed you from the beginning. We should have given you time from the beginning. Because it looks as if you are going.
My lords, I'm not. My lord, respectfully, my submission is that that decision that was delivered by this court on Tuesday, by another panel of this court on Tuesday, that decision was in clear error. And it was in error because it was not consistent with a pattern of decisions which I have referred to, in which this court has exercised its discretion to grant leave for the filing of a statement of case. And my lord, my fundamental submission is that this court, in the exercise of its discretion in hearing a review, is able to consider an application for a supplement to the statement of case. And my lords, I am respectfully submitting that the critical consideration for this court is really as to whether that supplement to the statement of case will enable this court to administer justice. And in a matter such as in that case, where the court was being urged to allow for the statement of case, not only because even a ruling in respect of which the original statement of case had been made, that ruling had not been made available to the party, but also because, as the court, as was indicated, there were a number of unreported decisions which the court was now being furnished with. So, my lord, where the application to file a supplement is to enable the court to be furnished with additional decisions of itself, which decisions are binding according to the constitutional provisions governing the exercise of jurisdiction. My respectful submission is that this court is able to exercise the jurisdiction for that supplement to be made available. Now, in this case, as your lordships will see from the drafts that we have submitted, the draft of the review, the draft of the supplement, we actually seek to provide this court with further assistance by way of additional authorities that are made available. Now, my lords, if I may, just before concluding, if I may touch on this question of amendment and how it differs from the supplement from the statement of case, which has been raised by your lordships. Now, my lords, in respect of appeal, yes, there is a specific right provided for applying for an amendment. There is a specific right. And my lords, my respectful submission is that the distinction between that and the review situation is fairly simple. The distinction is as follows. In the case of the appeal, the appellant is given a distinct right to ask to amend. So that is a specific thing provided for in the rule. In the case of a review application, my respectful and humble submission is that it is open to the court in the exercise of its discretion in hearing the review, where it finds it appropriate in the interest of justice to allow for the supplement to the case. So that is the distinction that I wish, in answer to your ladyship's question earlier, that is the distinction that I wish to make clear. That in the case of an amendment to a case in an appeal scenario under, I believe it's 1511, in that case, it is explicit that any party may at any time before judgment may apply. So there's an explicit opportunity provided to parties at any time before judgment to apply to amend their case. Now, in the review rules, there is no such equivalent. But my respectful submission is that that is because in the context of a review, what your lordships may do is within your broad mandate in the interest of justice to consider what is brought before you. So, my lord, for instance, respectfully, for instance, if in the context of an application for review, a matter that relates to compliance with the Constitution is being sought to be raised before you, as your lordships have made clear in many cases. When a matter related to the Constitution is being brought and enforcement, or there's an issue of breach of the Constitution which needs to be addressed, like was done in the famous Balkan energy case and so on, in that case, your lordships will, of necessity, respectfully, exercise your jurisdiction to entertain it, because your lordships are here to uphold the Constitution, no less, no more. So, respectfully, that is the difference between the opportunity provided under 1511, where appeals are concerned, and the review jurisdiction. Now, yes, it is conceivable, it would have been possible for the drafters of these rules to say that they are importing the same specific rule about amendments into the review jurisdiction. It would have been possible for them to do that. But, and I do not wish to enter into the minds of the justice of these rules of court, because they are generally a very distinguished panel of, professional judges and so on. And I do not wish to pretend to know their minds, but suffice it to say that in this CI 16 as it exists, they did not provide for that specific amendment rule when it came to review. They didn't do that. And my respectful submission that one cannot imply from that, therefore, that this court, in the exercise of its review jurisdiction, is bound from entertaining an application which involves an amendment. Because, in my respectful submission, this court has the jurisdiction and it has the opportunity in exercising its authority as far as reviews are concerned to consider what is in the supplement, what is, especially when a draft has been provided, and what is in the proposed amendment. And this court is able, in the exercise of this jurisdiction, to consider the matter.
Yes, my lords, we are opposed to this application on point of law. My lords, this honorable court has 6 distinct jurisdictions, different, one of which is the review jurisdiction. Lords, the rules governing review are very, very strict. And parties who seek a second bite of the cherry by way of review must strictly comply with it. My lords, insofar as the application before this court and all the other applications filed by the applicant seek to undermine CI 99, which basically, my lords, deals with my lords, I am dovetailing the point that the review jurisdiction is very, very strict. Yes, and I'm saying that the nature of the review do not permit the grant of this application. That is why my learned friend has not been able to cite one single authority on the point. All the references made, my lords, are in respect of appeals, and some regarding original jurisdiction. Original jurisdiction.
I must. The first, yes.
We will give you leave to respond appropriately, yes.
Well, that's my submission. That is my submission.
Yes. My lords, we are opposed to this application. First, our submission is that this review jurisdiction of this court is a very special jurisdiction. And you are, because of its special nature, parties are given only a month within which to bring an application. They cannot apply for leave for extension of time to bring an application for review, unlike an appeal where parties are given 3 months, and even after that they may bring application for extension of time. My lords, this is because that jurisdiction seeks to have the highest court of the land review its own decision. Now, so no one comes to the Supreme Court applying to amend its review or grounds of review as of right. Where there have been cases where the Supreme Court has exercised its discretion to grant such amendment, they must be dependent, if any at all, on the specific circumstances of the case. My lords, our submission here is that the additional ground that the applicant seeks is on the face of it no ground at all. Because what the applicant is saying is that because Article 129, is it 4, refers to the power of the court to exercise all other powers of lower courts. Thereby, CI 47 has been raised to a constitutional status. My Lord, with the greatest respect, I think that that argument is misconceived. Because if that were so, then all laws, acts of parliament, other subsidiary legislation, including CI 99, because they have their roots from the Constitution, from the Constitution, therefore also have been raised to the same constitutional status. My Lord, on the face of it, this cannot be, it simply cannot be a valid ground. Let me also add, with respect, that the Constitution actually provides a rules of court committee to make rules to govern the procedures of the courts of our land, including the Supreme Court. Does that mean that CI 99 is also raised to a constitutional status? It is for this reason that I think that the court should not exercise its discretion in granting what is a palpably misconceived application. Okay.
You will give you 5 minutes to reply on point of law.
My lords, if I may start by responding to the last submission made by counsel for the second respondent. And if I may make it absolutely clear that nothing in my submissions suggests that I'm elevating CI 47 or any other CI to the status of a constitutional provision. Absolutely nothing in my submission. Second, I would respectfully submit that the right of review is indeed a right that is provided for in the Constitution. And your lordships have had the opportunity to address its significance in the case of Bernard Mona. My lord, it does, because
no.
and my Lord, yes, my Lord, what I was addressing was the fact that
the nature of the rules that have been carved by the Rules of Court Committee,
we're not allowed
on Rule 54, we cannot entertain an amendment. That is their case, or supplement.
Right, my Lord.
That's why, Mr. Chairman, that's why you began your argument, your submission by saying that you are invoking the inherent jurisdiction of the court.
That is correct.
Yes.
That is correct. So my Lord, very well. My Lord, I will not refer to that case. I was going to refer to part of the judgment, but for the moment, without reference to that judgment, I just wish to say in response to that matter that in our respectful submission, the additional ground that we seek to bring, which relates to Article 1294, in our respectful submission, will also enable the court to consider the extent of its powers, the extent of its discretion in order to hear the review that we brought before the court. So that article of the Constitution is an important basis for the exercise of the discretion that we're seeking to bring. That is what makes that relevant. Now, my Lord, as far as counsel for the first respondent submission are concerned, my only response is that counsel has entirely misunderstood the nature of the application before this court. He's misunderstood the nature of the application before this court. In
my Lord, with the greatest respect,
because in the nature of the application that we have brought before this court, we are saying explicitly that this court, under its inherent jurisdiction, in the hearing of the review application, has a range of powers that it may exercise in the interest of justice. It is absolutely also not correct that we did not cite any case concerned with a review. The case of Elistamako and the Republic, which was the first case that I cited, was precisely in the nature of a review. So it is simply false for anybody to say that authorities we cited did not include something on review. Furthermore, we demonstrated that on this particular aspect, the exercise of the review jurisdiction cannot be any different from the provisions regarding an appeal in this particular aspect. That is all.
Please, you rise and consider.
all rise.
That's my friend over there. Hey, Azoto! Hey, Azoto!